All right. Good afternoon, everyone. Thank you so much for attending the 45th Annual Robert F. Wagner National and Labor Employment Law Moot Court Competition's final round. Before we begin, we would just like to take a moment to extend some thank yous, as well as introduce this year's final round bench. Firstly, thank you all so much to the New York Law School Moot Court Association for your assistance and dedication to this year's competition. Thank you to our chair, Heidi Moore, who will serve as our bailiff for the final round. We would also like to extend a special thanks to our authors this year, Liza Blazik and Erin Luhane, as well as our editors, Kirsten Kovacs, Mariah Abley Brown, and Matthew Fonman.
We would also like to thank Susan Torado, who has supported us through this entire process. Thank you to Professor Arthur Leonard and Scott DeLuca for their advice and counsel on the 2021 Wagner Fact Pattern and Bench Brief. Finally, we thank our faculty advisor, Professor Ann Schofield Baker. Professor Baker has been teaching at New York Law School for 10 years. In addition to Moot Court, her courses include Trial Advocacy, Advanced Legal Methods, and Deposition Skills Intensive. She has also been an intellectual property and corporate commercial trial lawyer for the last 25 years and still maintains a full private practice. Thank you for everything, Professor Baker. We could not have done this without you.
You're welcome. Well, first, I would like to start by extending a heartfelt thank you and congratulations to the intrepid chairs of this year's Wagner competition, Madison Woods and Carrie Sartori. I will tell you that chairing the largest labor and employment competition in the country is a daunting task when we're not in the midst of a global pandemic. But moving Wagner to a virtual format in the middle of a global pandemic was a monumental endeavor. And Carrie and Madison rose to the challenge at every turn. So I thank you. I would also like to thank Jorge Rodriguez, who was the wizard behind the curtain. Jorge made all of the technical magic happen on Zoom, and he had a small army from both the Office of Event Management and Information Technology, who provided technical support to each and every Zoom courtroom, and there were many all at the same time. So I'd like to thank them. And as an aside, I heard that by the end, all of the IT folks were debating the veracity of everyone's legal arguments, which I think is just awesome. I would also like to thank the 188 attorneys who judged the earlier rounds both yesterday and Friday. Wagner just can't happen without you, so thank you. And lastly, I'm truly privileged to support the New York Law School's incredible Moot Court Association. It's an honor to help you develop and hone your advocacy skills and cheer you on as you tackle some of the country's most cutting-edge legal issues. The country needs more great lawyers right now, and great lawyers you will be. With that, I am pleased to introduce the Academic Dean of New York Law School and the Rita and Joseph Solomon Professor of Wills, Trusts, and Estates, William LaPiana.
Thank you, Professor Baker. Good afternoon, everyone. On behalf of the faculty of New York Law School, I welcome all competitors and guests to today's Wagner Moot Court competition. This venerable competition has been indelibly marked by the coronavirus pandemic. The mode of the competition is now virtual. And while this way of holding the competition may never be repeated, we see every day the work of our courts indelibly changed by new ways of working remotely. Your experience in making your arguments outside of each other's physical presence will surely make you better prepared for the world in which you will practice. The subject of this competition has also been marked by the pandemic. Employment law is entering a new era of importance as the public health crisis has laid bare many truths about what it is like to work in America today. The issues presented by today's Moot are only a sampling of the legal, economic, and moral questions raised by this difficult time. The Wagner competition is one of the ways New York Law School, faculty, students, and staff, in concert with all of American legal education, is taking its part in helping our city and our nation recover in every sense from a great time of testing. That recovery requires all our efforts to ensure more than a return to the status quo ante. We must all work together to remedy the weaknesses and wrongs the pandemic has laid bare. Again, welcome and congratulations to all the competitors.
Thank you so much, Dean LaPiana. At this time, we will give the floor to one of our authors, Liza Blazik, for a brief summary of the facts for this year's competition.
Thank you, Madison. Good afternoon, everyone. I'm going to be giving a brief overview of the facts of our case today. Petitioner Jeff Exotic is the owner of the Tiger Lounge and has taken great pride in the quality and aesthetic of his lounge throughout the years. Respondent Carol Buskin is a 27-year-old female and has been employed by Mr. Exotic since she was in college. Buskin is a full-time server and typically works the dinner shift at the lounge Tuesday through Saturday. Exotic has owned and operated the lounge for 20 years, and as a result, the lounge has become a long-standing staple in the community. Lounge employees are trained to ensure that each customer is fully immersed in the quality, aesthetic, and vibe of the lounge. In March 2020, a global pandemic broke out across the nation, including in the state of Wagner. Consequently, many small businesses, including the lounge, had to temporarily shut down for health and safety purposes, namely to reduce the spread of novel virus COVID-19. Restaurants and bars began reopening in early April 2020 for takeout orders only. Buskin, as a longtime employee of the Tiger Lounge, was among the few staff members that Exotic called in to help with deliveries and other responsibilities. In response to the COVID-19 virus, the Wagner Health Commission adopted a set of guidelines for restaurants and bars, such as the lounge, that small business owners were expected to follow to reduce the spread of COVID-19. The Wagner Health Commission announced that restaurants and bars were allowed to reopen for in-person dining at limited capacity beginning in June of 2020. Mr. Exotic was very excited about being able to reopen, considering he, like many other small business owners, faced significant hardship resulting from the outbreak of COVID-19. As such, Exotic implemented safety measures to keep guests and employees safe while maintaining business as usual. Some of the measures that Exotic took at his lounge included employees taking a biweekly COVID-19 test, remaining 6 feet apart from each other when possible, the installation of a ventilation system in crowded dining areas, and ensuring all tables were 6 to 10 feet apart. On June 3rd, 2020, when the lounge reopened, Exotic posted a memorandum in the server station explaining new procedures in response to COVID-19, with a copy of the Wagner Health Commission guidelines attached for all employees to be put on notice. On June 14, 2020, only a few days prior to Buskin's final shift at the Tiger Lounge, Buskin attended an outdoor birthday party and posted photographs from the event to her personal Instagram account. In these photos, she was not wearing a mask or social distancing. Business at the lounge was busy on Saturday afternoon into the evening on Buskin's last shift. She arrived at 4:40 p.m. for her usual dinner shift that began at 5 o'clock. Shortly thereafter, Buskin noticed that none of her coworkers were wearing masks. She pointed this out to a coworker and asked why no one on staff was wearing one. The coworker responded that the boss, speaking about Mr. Exotic, was in rare form, and he said the masks were killing the vibe and he did not want his staff members wearing them. Buskin was concerned about her own health and that of the customers, so she proceeded to wear her mask in compliance with the commission's guidelines. Around 7:30, when Exotic called Buskin over, he told her to remove her mask. Buskin refused and questioned Exotic, to which he repeated, "Remove your mask, it does not match the aesthetic of my establishment." Buskin pleaded with Exotic, stating that she did not feel comfortable working without her mask on, and Exotic suggested to Buskin that she worry more about her job and keeping him and the customers happy. Buskin reluctantly complied with Exotic's demands to remove her mask and continued with her shift maskless. Shortly thereafter, one of Buskin's regulars came in the lounge for dinner, and the customer asked Buskin why she was not wearing a mask and requested that she please put one on while serving her and her table. Buskin apologized to the customer, and she wore her mask for the remainder of her shift against Exotic's orders. At the end of the night, around 10 o'clock, when the lounge had mostly cleared out and the staff prepared for closing, Exotic came out from his office and saw Buskin wearing a mask. He yelled at her and stated, "Didn't I tell you to take that off? Your shift is over, go home." Buskin was not scheduled to work again until Tuesday, June 20th. On Monday night, Buskin began to feel ill. She was running a high fever and noticed she was unable to taste or smell anything. That night, she texted Exotic and told him she was unable to work her shift on Tuesday because she believed she was experiencing symptoms of COVID-19. She was scheduled to get tested the following morning. Exotic did not reply. On Tuesday, the next day at noon, Buskin sent Exotic a picture of her positive COVID-19 test results and informed her that she was unable to come to work and she would be undergoing a 14-day quarantine. Exotic did not reply. On the last day of her quarantine, Buskin texted Exotic and told him that she was still testing positive for COVID-19 and would let him know when she received a negative test. Exotic responded, "No worries, business is slow, had to make schedule changes, I wish you luck." Later that day, a coworker told Buskin that multiple people on staff were out sick with COVID-19. Buskin also found out that on the day of her last shift on June 17, 2020, Exotic had asked other staff members who had previously tested positive for COVID-19 to come into work. Those staff members were nearing the end of their quarantine and were no longer showing symptoms, but Exotic did not ask them to submit proof of a negative COVID-19 test before coming in for their shift. When Buskin received her pay stub in the mail, it only reflected the pay that she was entitled to from her June 17, 2020 shift. She texted Exotic and asked why she had not received the pay to which she believed she was entitled to for her sick leave. He replied that he would not pay her if she did not work. Buskin informed Exotic that he must pay her according to the Wagner family's first COVID Response Act, and he repeated that he would not pay her if she did not work and that she should stop letting COVID-19 run her life. The following day, Buskin texted Exotic and told him that he could put her back on the schedule because she had finally tested negative. However, she informed Exotic that she would only work if she could wear a mask during her shifts. Exotic told her no mask. Buskin immediately quit her job at the lounge. In response, Buskin commenced an action against Exotic, asserting 3 claims. First, Buskin alleged that Exotic failed to provide a safe working environment in violation of public policy. Second, Buskin asserts a common law claim for constructive discharge because Exotic would not let her wear a mask while working. And third, Buskin asserts a common law gross negligence claim, asserting that Exotic's refusal to permit her to wear a mask inside of the lounge was grossly negligent and the natural and proximate cause of her COVID-19 infection. Mr. Exotic filed a motion to dismiss on all claims, which was granted at the trial court for the County of Hillsborough. Ms. Buskin appealed the order granting Exotic's motion to dismiss, and the Court of Appeal for the State of Wagner reversed the holding of the trial court. The Supreme Court of the State of Wagner will hear oral arguments on the following 2 issues. First, whether an employee has a common law claim against an employer for the employer's alleged violation of public policy set forth in state law related to maintaining a safe work environment, and concurrently, whether an employee subjected to an unsafe work environment in violation of public policy may also pursue a common law claim for constructive discharge based on a single instance of being placed in an unsafe work environment. And second, whether an employee is barred from pursuing a claim of negligence under Section 12402A of the Wagner Workers' Compensation Law when the employer allegedly failed to provide a safe work environment during a novel pandemic. Thank you, everyone.
Thank you so much, Liza. At this time, we would like to formally welcome our final round bench. First, we will start with Judge Patricia Williams. For over 40 years, Judge Patricia Williams dedicated much of her impressive legal career to public service. She has served as an assistant United States attorney for the Southern District of New York, a judge for the Criminal Court for the City of New York, and an acting justice for the Supreme Court of the State of New York.
Dean Anthony W. Crowell is our 16th Dean and President of New York Law School. Prior to his appointments, he served as counselor to New York City Mayor Michael Bloomberg. For more than a decade in City Hall, he successfully managed a broad portfolio of legal, regulatory, legislative, governance, administration, and operational matters for New York City.
Scott DeLuca, Senior Counsel at Kavanaugh Cook LLP, has devoted himself to labor and employment law for nearly 25 years. He counsels clients on a myriad of labor and employment law issues and has litigated claims throughout the United States involving employment discrimination, wage and hour claims, including class action claims, employment agreements, and restrictive covenants. Madison, I believe you're on mute.
Thank you. Nothing quite like a technical function or misfunction. Yvette Gordon is the senior counsel in the litigation department for ADP, a leading provider of human capital management solutions. She is a distinguished expert in labor and employment law. For more than 20 years, she has represented employers before state and federal courts and administrative agencies and has advised and trained human resource professionals in all aspects of the employment relationship, from recruitment and hiring to termination of employment and severance.
James McQuaid is a partner in the employment law and litigation group at Orrick in New York. He represents clients in high stakes employment, trade secrets, and restrictive covenant litigation throughout the United States and has extensive experience defending employers on a broad range of employment matters, including whistleblowing, discrimination, retaliation, and wrongful termination matters.
So thank you so much to our esteemed judges for joining us. We also want to say a thank you and congratulations to every competitor that has competed in the Wagner competition thus far. You are all incredible and you should all be very, very proud of yourselves. So without further ado, we will now begin our final round. Best of luck to the competitors.
Petitioners, will you be reserving time for rebuttal?
Yes, we're going to split, we're going to request 2 minutes, and we would like to split that time between the both of us. So 14 minutes for petitioner 1 and 14 minutes for petitioner 2.
Thank you.
Thank you.
Chief Justice, shall I
Good
begin?
afternoon, all of the contestants, petitioners, respondents, your family, any friends who are also attending remotely. I am truly honored. I know you won't believe this, but it's true. I'm truly honored to be here at all, mainly because if you look at your panel, you have people who really understand this area of law, who practice in it. This is a wonderful experience for you, an absolutely marvelous thing that you can't imagine not having. But if you're old enough, you'll remember there was a time when this type of national competition did not exist. So this is a wonderful experience. And no matter how it turns out in the end, all of you will be so much the better for it. Don't worry about the fact that these experienced lawyers will probably give you a great deal of problems. That's what they're supposed to do, so that when you get out in the real world, you'll say, oh, this is easy. This stuff is easy compared to what the justices did. So welcome, enjoy this. It will be something that you will remember and hopefully have a great time doing. Well, if you may call the case that's ready for argument at 1 o'clock.
Oyez, oyez, oyez. All those who have business before this honorable Supreme Court of the state of Wagner are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Supreme Court of the state of Wagner is now in session. Justices Crowell, McQuaid, DeLuca, Gordon, and Chief Justice Williams presiding. The first case on the calendar this 14th day of March of 2021 is Jeff Exotic versus Carol Buskin.
May I proceed?
Petitioner ready to proceed.
Yes, Your Honor.
You may.
Thank you. Chief Justice, and may it please the court, my name is Corey Stanford, and along with my co-counsel, Jonathan Veras, I represent the petitioner in this matter, Mr. Jeff Exotic. At this time, I would like to reserve 2 minutes for rebuttal. Thank you, Your Honor. Your Honors, there are 2 issues before this court today. First, I'll address why this court should not recognize common law claims for failure to maintain a safe work environment and constructive discharge in the state of Wagner. My co-counsel will discuss why the respondent may not bring a negligence claim under the Wagner's workers' compensation law. Your Honors, petitioner's argument today can be summed up in one word: balance. This matter gives this court the opportunity to restore the balance of rights between employer and employee and continue the Wagner Court's longstanding tradition of encouraging capital formation and commercial enterprise. The Wagner legislature adopted the Wagner Employment at Will Act of 1963 and the Wagner's Workers' Compensation Law to provide its employees with a statutory remedy to recover for workplace injuries and to make workplace discrimination or retaliation unlawful. Your Honors, even in the midst of a novel pandemic, these statutes aptly balance the rights of both the employer and the employee. As such, by holding that the respondent may bring common law claims for failure to maintain a safe work environment and constructive discharge against the petitioner, the Court of Appeals destroyed the balance of rights in what's been an incredibly challenging time for small businesses. As such, this court should reverse the Court of Appeals decision for the following three reasons. First, the respondent has an adequate statutory remedy under the Wagner Employment at Will Act and Wagner's Workers' Compensation Law. Second, recognizing a common law claim for constructive discharge is inconsistent with both existing precedent under state and federal law. And third, courts are particularly ill-suited to address workplace policy or strategy with respect to COVID-19. Your Honors, with respect to my first point, in its reasoning on page 16 of the record, the Court of Appeals cites a case for the New Mexico Supreme Court of 1993. That case is Gutierrez versus Sundancer Indian Jewelry, Inc. Your Honors, in Gutierrez, an employee brought suit against their employer for wrongful discharge and requesting that the New Mexico Health and Safety Department investigate chemical usage and employee health problems at that employee's employer.
Counsel, I'm concerned by your suggestion that we are ill-suited to handle this situation. If we aren't able to handle it, who should?
Your Honor, and this exact issue was addressed, and this goes to my third point, as you noted, and this exact issue was addressed in Palmer v. Amazon.com, which is a fairly recent case from the Eastern District of New York, November of 2020 to be exact. We should leave this to the legislature. If the legislature, Your Honor, wanted to act, we should leave it to them. And I will quote from Justice Kogan in that opinion. This is a coronavirus case, Your Honor, in the constructive discharge context. Justice Kogan noted, courts are not experts in public health or workplace safety matters. They lack the training, the expertise, and the resources to oversee compliance with an ever-evolving industry standard and guidance with respect to COVID-19. Your Honors, today, this respondent's relief requires both a technical and a policy expertise with respect to workplace safety. Respondent requests that this court analyze how Mr. Exotic's workplace practices and policies impact transmission of what's been and what was in June of 2020 a poorly understood disease. Determine how those workplace policies created an unsafe workplace or otherwise violated certain state or federal standards, and potentially implement costly regulatory schemes and new workplace policies.
Wait a minute.
Counsel, sorry, Judge, go, please, Chief Justice.
How does this become so costly? We're talking about masks. Masks that, of course, Exotic knew about because it posted the Wagner health conditions recommendations on the wall early in June. And early in June, those people who have the expertise that you say we don't have said that masks were a good idea. Why is that a burden to the employer?
Your Honor, the masks are not a burden per se to the employer. Rather, we would characterize, and petitioner would argue, that the mask issue is a regrettable decision on the part of the employer. Mr. Exotic regrets that decision, but, Your Honor, taking this back to the theme, balance. Mr. Exotic was tasked with balancing competing interests in this case. As stated on page 3 of the record, Your Honor, Mr. Exotic expressed to the respondent that his business was struggling, and the whole essence of petitioner's business is the vibe and is the aesthetic of his lounge. He has to balance the profit margin, he has to balance the safety and the interests of his employees, along with the interests of his customers. He balanced, just like this court today, Your Honor. This court has to take in petitioner's arguments, respondents' arguments, and balance those with the case law, with the public policy, with existing.
But counsel, the balance has to weigh a bit in favor of the employee, because the legislature has spoken and said specifically, and I'm pointing to the Wagner Employment at Will Act of '63, that it's the fundamental and legally established public policy. So because of that, don't we have to take the balance in favor of the employee?
Your Honor, and while Wagner does recognize that public policy, other jurisdictions such as Colorado, Michigan, and Oregon have refused to recognize common law causes of action for wrongful discharge when there is an adequate statutory remedy available for the claimee. And this is specifically cited by the trial court in Olson versus DST Industries, which is a 1981 Supreme Court of Michigan case. Your Honors, and this goes to my first point, is that there is an adequate statutory remedy for the respondents to recover today. She can claim that it was unlawful under Section 3A of the Wagner Employment at Will Act and seek to recover under the statutory scheme that is set up and which will be discussed by my co-counsel in the Wagner's workers' compensation law. Therefore, there's no reason for this court today to create a common law claim for failure to maintain a safe work environment or a constructive discharge when there is an adequate remedy available for the respondent here today. Second, Your Honor, the United States Supreme Court has addressed constructive discharge in only two contexts. First, in Shurtan versus NLRB, a 1984 Supreme Court case, the court found that when an employer, in that case, created such intolerable work conditions against union employees, which he was bargaining with, the court found that the employee in that case had no alternative but to resign. Second, in Pennsylvania State Police v. Suitors, which is in 2004, the court then extended constructive discharge application to civil rights claims, specifically egregious forms of sexual harassment and racial discrimination. Taking, for example, the employer in the Pennsylvania State Police case, that employer was exposing his private areas to the employee. Thus, such egregious sexual harassment left that employee with no other choice but to resign here, Your Honors. And this is consistent with the majority of states, 30 states, and this is delineated further in Appendix F of our brief, Your Honors. 30 states recognize that in order to bring a constructive discharge claim, it has to be a part of a larger statutory scheme, something like egregious forms of sexual harassment, civil rights claims under the Civil Rights Act, and racial discrimination also under the Civil Rights Act. Here, the Court of Appeals put Wagner with the only 6 states would recognize a common law claim for constructive discharge on its own. Your Honors, we would argue that that is inconsistent with both state and federal precedent. As I stated, the federal courts have only recognized this common law claim as part of a more broad statutory claim such as under the Civil Rights Act or sexual discrimination under Title VII. However, Your Honors, even if this court today were to adopt a common law claim for constructive discharge, the respondent still cannot recover for a single instance issue because that requisite high standard for constructive discharge is incredibly high. And the
Counsel, if we could just turn to the common law safe workplace issue for just a second. If we disagree with you and we hold that the Wagner Employment at Will Act does support a common law claim for the failure to maintain a safe work environment, what standard should we use to evaluate those types of claims to determine whether or not the respondent has asserted a plausible claim, if we were to use the federal standard for determining on a motion to dismiss?
With respect to the failure to maintain a safe work environment, Your Honor, it would be a reasonable person standard, and that is consistent with the constructive discharge claim as well, Your Honor, and that is what's delineated in Turner v. Anheuser-Busch Inc., which is a 1994 California Supreme Court case. We're relying on Turner v. Anheuser-Busch because that is exactly this case that both the trial court in its reasoning and the Court of Appeals cited in its reasoning as well, Your Honor. With respect to the Go ahead.
Why wouldn't we apply a strict liability standard to a situation like that? When you're putting somebody's health and safety at risk, shouldn't strict liability be the right standard?
Petitioner would disagree, Your Honor. Strict liability would essentially say what the Court of Appeals said. You can do 9 out of 10 things to limit the transmission of the virus, but if you fail to do one thing, you're held liable. However, we should look at this as a balance, Your Honor. Balancing, Mr. Exotic balanced what was contained in the Wagner Health Commission guidelines and balanced that with the competing interests at his workplace. As such, Your Honors, he made the regrettable decision to request that Ms. Buskin not wear a mask. However, because of that balance, he determined that because the vibe and aesthetic of his lounge had kept it going, he's the sole proprietor of his business, Your Honor, for over 20 years, he felt and exercised his best business judgment, balancing all the available information that was available to him at the time in June of 2020, and decided to take certain measures, but did not take one. For this court today, Your Honor, to hold that rises to the level of constructive discharge or failure to maintain a safe work environment would be pushing small businesses further into extinction than the pandemic already has.
Counsel, isn't it true that Exotic did not adhere to its own policy that it had created itself?
Your Honor, and while I believe you're referring to the lack of contact tracing or allowing his employees to get the proper testing before they return to the workplace.
Correct.
However, this was exactly, and I'll turn back to the Palmer via Amazon.com case. This is exactly the case, the factual scenario that happened in Palmer via Amazon.com. And while I'm not comparing Amazon to the small Tiger Lounge in size, however, in Amazon, the employees were not contact traced. There was no sanitation available to them. They were warehouse associates running through this large JFK 8 warehouse, touching the same boxes, running by each other, may or may not have had masks on. Here, Your Honors, this is the same factual scenario. And that's where, going to my third point, the court in Palmer said it is not within the court's purview. They lack that expertise. They lack the training or the resources to implement new policy or workplace strategy with respect to the COVID-19. Your Honors, taking this all into consideration, taking it back to that balance of factors. Today is an opportunity for this court to restore that balance of rights. Palmer said, if you are Amazon, large business, we are not going to interject as to what your workplace policy or strategy is today. This court should take the similar approach with respect to a small business. Small businesses have been struggling throughout this pandemic. Mr. Exotic, and as my co-counsel will discuss, did what he could with what little he had. He balanced all the competing interests in this matter and allowed his business judgment to take over. And while he made a regrettable decision, that regrettable decision should not rise to the level of failure to maintain a safe work environment or the level of egregious conduct needed to plead and prove constructive discharge in this matter. Thank you, Your Honors.
May I proceed?
Yes, Mr. Varas?
Thank you, Your Honor. May it please the court. Good afternoon. My name is Jonathan Varas, and as my co-counsel, Mr. Stanford, mentioned, we represent the petitioner in this matter, Mr. Jeff Exotic. Your Honors, this is a case about a small business owner doing what he thought was right, doing what he could with indeed what little he had to not just save his business of over 20 years, but to ensure that his employees had gainful employment in a dangerous and uncertain time, employees such as the respondent. As such, Mr. Exotic asked this court to reverse the Court of Appeals decision for 3 reasons. 1, Mr. Exotic's mask policy did not violate any federal or Wagner statute, rule, or regulation as required by Hanley. 2, the respondent failed to allege sufficient facts to show that this no mask policy was the proximate cause of her injury. And 3, because the Wagner's workers' compensation law is the exclusive remedy in this situation and the better one. Your Honors.
Why is it better?
Because, well, Your Honors, that goes to the third point. On record page 9, footnote 7, it states clearly that Wagner's workers' compensation law was adopted with the express intent of putting the employer and the employee on the same bargaining plane. That prior to the Wagner's workers' compensation law, employees were forced to bring their tort actions or their compensation actions in tort, which would result in costly and extensive litigation, of which, as the record states, they very rarely ever recovered. Now, the purposes of this workers' compensation law is to provide a quick remedy. Now,
Apparently not, because your client didn't even bother to pay the sick leave that she was due under another statute. So why is it that you're telling us that this is so much faster and better for the employee?
well, Your Honor, the sick leave, yes, if the respondent were to allege any damages, the back pay and the sick leave would be owed to her. I believe you're speaking under the Families First Coronavirus Relief Act. However, the record is silent as to if the respondent even attempted to pursue any remedies under the Wagner's workers' compensation law. And the purposes, again, of this quick and prompt judicial resolution.
Didn't she ask for her pay, her sick pay, more than once?
She asked for her pay, Your Honor, on record.
And wasn't she told if she didn't work, she didn't get paid?
She was told by Mr. Exotic that if she did not work.
And at that time, Mr. Exotic knew that she was out because of COVID?
At that time, Your Honor, she had texted saying she was negative and she was attempting to come back to work. But again, the record is silent as to whether she pursued that remedial measure under the workers' compensation statute. Instead, she attempted to bypass the workers' compensation statute directly by going through the exception to the immunity standard held in Wagner workers' compensation law. Now, the Superior Court and the Court of Appeals in this matter applied the Hanley test, which comes from the Hanley v. Union Carbide Corporation, which is a Fourth Circuit case from 1986 applying West Virginia Code. It's important to note that West Virginia Code and West Virginia case law surrounding the Hanley test is informative, particularly here, because record page 28, footnote 16 states clearly that Wagner's workers' compensation law is adapted from West Virginia law. And the Hanley test is a 5-element test that requires all 5 elements to be met, or else the entire test fails. Now, those 5 elements are the specific unsafe working condition, which presents a high degree of risk and a strong probability of serious injury or death. 2, that the employer possesses subjective realization of this unsafe condition. 3, that this unsafe condition was in violation of a federal or state statute, rule, or regulation. 4, that this employer, in light of the first 3 elements, thereby intentionally and knowingly exposed the employee to the unsafe condition. And 5, that this unsafe condition was the proximate cause of the employee's injury. Now, Your Honors, this 5-element test may be summed up into one word: specificity. And no element embodies that specificity requirement quite like the third element, which requires that a specific statute, rule, or regulation be applicable to this working condition. Turning first to the West Virginia Code and describing the importance of this element, the West Virginia Code states clearly that it must be, and I quote, specifically applicable to the work and working condition alleged. And not only that, but the statute cited must be intended to address the unsafe working condition alleged in the case.
Well, counsel, weren't there a series of pronouncements by the state of Wagner and the CDC and a variety of other legal sources to state that wearing masks and contact tracing and the other safety protocols that your client even recognized to some extent, doesn't that really answer the question that you're suggesting is unanswered?
Well, Your Honor, referring to the record, the only evidence in the record of any authority requiring masks would be the guidelines promulgated by the Wagner Health Commission. And those guidelines are just that. They're guidelines. They contain permissive language of which Mr. Exotic was encouraged or discouraged from following. And not only that, but their language was contradictory. Now, an example of a case where a plaintiff cited only guidelines.
How were the standards contradictory?
Well, for example, Your Honor, under section ABII, 2 sentences stand out notably, that it says, and I'm paraphrasing just a little, it states that employers should encourage masking. And the very next sentence, it states that employees must wear a mask. And this goes back and forth to where it creates a confusing situation for an employer to be able to encourage masking or to encourage something that is also at the same time required. So these guidelines present a situation where it's permissive and it allows the employer to choose how to run their business in a safe and effective way. Now,
your client, I'm sorry, but your client also issued his own memorandum, which I have as Exhibit B, and he specifically suggested there that wearing a mask was part of what he expected, isn't it?
Yes, Your Honor. Record page 26, I believe, is the memorandum, and it discusses the different mitigation efforts that Mr. Exotic was putting in place at his lounge.
So
Notably,
we have these, you suggesting that they're only guidelines, but we could conclude that they carry the force of law and they meet the third part of the Handley test.
Your Honors, it is well within your purview to conclude that these guidelines have the force of law. However, petitioner would strongly caution against doing so. Again, given the permissive language of these guidelines and concluding that these guidelines would carry the force of law now, almost a year later after this situation occurred, is going to tell small business owners across the state of Wagner that how you interpreted these guidelines a year ago doesn't matter, because now they have the force of law and you're going to be on the hook for mistakes you made a year ago when you were trying to do the best with what you could with what guidance you had at that time. Now, under the Handley test,
what statutory provisions compelled the petitioner to install new ventilation and to put the tables 6 to 10 feet apart and so on? Was there a statutory provision that required him to do that? Or was that part of the guidelines?
No, Your Honor, there was no statutory provision, and the guidelines do guide and encourage social distancing.
So you're saying that the guidelines are reasonable because if this is a pandemic we're talking about, and we're talking about health commission guidelines, and you're saying, well, my client is free to pick and choose which ones he wants to utilize, even though he posts the one about masking. What was the purpose of posting it?
Your Honor, it's not so much that insinuating the petitioner may pick and choose which parts of the guidelines he may follow. The posting of the guidelines shows that Mr. Exotic did take this situation seriously, that he did implement those multiple mitigation efforts at his own expense, that despite the significant hardships that it states that his business suffered on record page 3, he installed that new ventilation system. He spaced those tables 6 to 10 feet apart. He did encourage social distancing. But these guidelines just don't carry the force of law as per the Handley test.
If the masking, can you answer the question? If the masking and stay-at-home guidelines were not necessary and not significant and did not have the force of law, what was the point in posting them along with the measures that he did take?
Well, the point in posting them, Your Honor, would be the petitioner wanting to still create a safe environment in his restaurant. And while it's—
the wall?
Pardon me?
I said for the wall on which he posted it, because apparently he didn't want to create a safe environment for his employees or his customers. What was the purpose in posting it and telling the employees that it was being posted?
The purpose was to show the employees that there were multiple mitigation efforts being taken in the lounge, and that the information from the Wagner Health Commission guidelines would be informative. But Your Honors, if this court were to disagree and hold these guidelines as law, it does not negate the fact that this is a 5-part test requires all of these elements to be met, or else the entire test fails. And that goes to Helmick v. Potomac Edison Company, which is a West Virginia Supreme Court case in 1991. Now, that case was likewise decided at the motion to dismiss stage. And the court, as my co-counsel put it, balanced numerous factors. And turning to the West Virginia Code, it stated that there should be prompt judicial resolution in these situations to determine that if the plaintiff failed to allege sufficient facts to any one of the required facts, then a motion to dismiss would be proper. And that brings me to the second point, Your Honors, that the plaintiff, that the respondent in this matter, failed to allege sufficient facts to show that the no masking policy was the proximate cause of her injury in the situation. Now,
Counselor, isn't that a question to better be resolved during discovery? Shouldn't the plaintiff or the respondent in this matter have the opportunity to establish facts that support her allegation that her employment was the proximate cause of her injury? Why is this appropriate for dismissal before there's been any discovery?
Well, Your Honor, it goes to 2 points. One, again, judicial promptness, in which it is actually the best interest of the employee that if this case were to be dismissed, they might still be able to pursue other claims under the Wagner workers' compensation law. And the second is the court in Helmick asked the same question, but decided that the motion to dismiss stage is still proper, even though the plaintiff in that case still argued that it was owed discovery. And a trier of fact at the very beginning in these pleading stages is allowed to assess these alleged facts and determine under the Ashcroft standard whether they meet that plausibility line or fall short and remain in the possibility era. And in Yeater v. Allied Chemical Corporation, which was a case involving the alleged negligent storage of chemicals, the plaintiff in that case was able to produce expert testimony. And following that expert testimony, where the most the expert was able to testify as to how these chemicals or the storage of the chemicals might approximately cause the death of that the plaintiff. So this was brought on behalf of the plaintiff's family. The expert was only able to argue or to conclude that it was more likely than not that these chemicals caused that injury. And the court still held that that was not sufficient under the Hanley standard for proximate cause. And the record also shows here, Your Honor, yes, Ms. Buskin was asked not to wear her mask that day. Prior to this, she attended that outdoor party, which as the Superior Court described on record page 12, was, quote, crowded with people. And this presents that intervening cause that is unforeseen by Mr. Exotic in this situation. And an unforeseen cause in the chain of events does defeat that plausibility standard under the Ashcroft standard. And that comes from Tolley v. ACF Industries from West Virginia in 2002. Now, Your Honors, this case again goes back to the balance and the restoration of that balance and what is best here. And what is best here is that the respondent pursue these claims under the Wagner's workers' compensation law. And a remanding of this case or an affirming of this case at the appellate court level would essentially put Wagner prior to the adoption of the Wagner's workers' compensation law and tell other employees to essentially get bogged down in the costs of litigation, small business owners like Mr. Exotic to do the same. And that is exactly what the West Virginia court decided to do after the Mandalis decision, which had a similar low bar negligence standard, and deliberately adopted the higher bar deliberate intent standard that the appellate court and Superior Court chose to apply in this case. And so remanding would put them on the same footing as before. Thank you, Your Honors. I see my time is concluded.
Thank you, Mr. Ferris. Defense, respondent?
May I proceed?
Yes, Ms. Raynor.
Thank you. Good afternoon, Your Honors, and may it please the court. My name is Alex Rayner, and my partner and I represent the plaintiff respondent Carol Buskin in this matter. I will be addressing the public policy and constructive discharge issues, and my co-counsel Ben Rowley will be addressing the gross negligence issue. This court should affirm the Court of Appeals' decision to deny Exotic's motion to dismiss and allow Ms. Buskin to proceed on her claims. Ms. Buskin has asserted a claim for wrongful discharge in violation of a public policy. The public policy is articulated in the Wagner Employment at Will Act of 1963, and the discharge here was a constructive discharge. Your Honors, we are at the motion to dismiss stage of this case, and we're simply asking the court to allow Ms. Buskin to proceed on her claims for 2 reasons. First, because Exotic unlawfully prioritized the aesthetic and vibe of his restaurant over the health and safety of his employees in violation of a fundamental, established, and publicly beneficial policy. And second, because Exotic forced Ms. Buskin to choose between knowingly exposing herself to a deadly virus and protecting herself and her community, effectively discharging her in the process. I'd like to turn first to Petitioner's assertion that Ms. Buskin should have brought her claim under the statute itself. First, there is no express cause of action under the Wagner Employment at Will Act. And even if there is an implied right of action, there's no enforcement mechanism and not even the suggestion of one. In fact, this is precisely the type of situation where courts in the past have fashioned a wrongful discharge in violation of a public policy tort. For example, in Kelsey v. Motorola, Inc., in the Illinois Supreme Court, the Illinois Supreme Court found that in order to uphold the public policy of the Workers' Compensation Act, a cause of action for retaliatory discharge at common law had to exist. Similarly, in our case, to uphold the public policy of the Wagner at-will statute, including the policy to maintain a safe working environment, which would protect our most fundamental interest, which is the health and safety of the workers, a cause of action for terminating someone in violation of that statute must exist under common law because it doesn't exist by virtue of the statutory language itself. And moreover, even if that is the case and the court finds that a remedy exists under the Wagner Employment at Will Act, Mr. Exotic must be conceding that there is yet another statutory or common law exception to the workers' compensation exclusivity. And so in either case, Ms. Buskin prevails. Now, turning to that public policy itself, it's articulated in the trial court's opinion on page 1 and 6 of the record, the appellate court's opinion on page 16, and in the Wagner Employment at Will Act. Like all other states, Wagner is an at-will employment state. However, the WIAWEP specifically states in section 1C that individuals are still expected to work in a safe and secure workplace that is free of obvious dangers that can reasonably be avoided. The key word here, yes.
I'm most interested in the constructive discharge piece.
Sure.
I'm not aware of any authority to suggest that an individual who's been subjected to a single act can state a claim for constructive discharge. Can you point us to any authority that would support that?
Sure, Your Honor. Actually, the Turner v. Anheuser-Busch case, which petitioner mentioned and which the trial court and the appellate court both rely on, specifically states that a single instance is enough as long as that instance rises to a certain level, typically an extraordinary or egregious level. And that's precisely what we have here. Now, for there to be a constructive discharge, Ms. Buskin needs to allege either that there was a pattern of discriminatory conduct or that aggravating factors existed that were so intolerable that a reasonable employee would feel compelled to resign. And that's what we have here. This is not a disagreement between an employer and an employee. This is an ultimatum that Mr. Exotic issued to Ms. Buskin, essentially saying, return to work, knowingly expose yourself to an airborne virus that has already killed 131,000 Americans and sickened 1.8 million, or quit and protect yourself and your community. In fact, the only reasonable choice Ms. Buskin had in this situation was to leave the job in order to protect herself and those around her.
Well, counsel, the problem with that is when Mr. Exotic gave that order about her returning to work and not wearing a mask, she had COVID-19. And at that time, there was the awareness of antibodies. So was she really exposing herself to this illness in a way that put herself and others at serious risk?
Yes, Your Honor. At this point, we still have no idea what the long-term effects of COVID-19 are going to be. And that's not just health effects, that's also economic effects. We don't know what her medical bills look like. We don't know what kind of economic effects she suffered in addition to not receiving her sick pay leave. So at this point, it's unclear whether she will continue to suffer injuries. We just don't know the extent of her injury right now.
But I guess my point is that how can she claim that she was constructively discharged if you're claiming that she was putting herself at risk? She wasn't putting herself at risk at that point. She had already had the disease. Coming back to work and not wearing a mask, did that really pose the type of safety threat that you're suggesting?
I see, Your Honor. She did not. There is nothing in the record suggesting that she already had COVID before she went to the restaurant, if I'm understanding you correctly.
No, after she had COVID and she finally tested negative, then he said, come back, don't wear a mask.
Mm-hmm.
And that's what you're claiming is this event that caused her to quit. So she already had the disease by that point. If she went back and didn't wear a mask, she wasn't putting herself at risk, was she?
Potentially, Your Honor. Again, at this point, we don't know whether people are able to get COVID again, whether returning to a situation where they could be around COVID positive people would lead to more difficulties in the future. And in fact, that's precisely the type of information we'd like to investigate upon discovery, speaking to expert witnesses about this issue precisely. Now, to your point about
But still, how does that support a constructive discharge claim? That's where I'm held up.
So, Your Honor, for there to be constructive discharge, Ms. Buskin needs to allege aggravating factors. And to do that, we need to look at the totality of the circumstances, which is precisely what Turner requires. In the totality of the circumstances, the situation itself was intolerable. It's not just that she wasn't allowed to wear a mask. It was also that he refused to follow state guidelines. He put her in close proximity to other maskless employees who he knew had tested positive for COVID and had not subsequently finished their quarantine or tested negative. He reacted hostilely repeatedly to her concerns that she expressed to him about her health, and he violated her statutory right to sick leave pay. So all of these things combined created a situation where Ms. Buskin was pressured to either continue to work in an unsafe environment or to quit. And that's precisely when a constructive discharge is appropriate. But turning back to the public policy claim itself, in order for there to be a public policy, that policy needs to be fundamental, publicly beneficial, and come from a statutory or constitutional provision. The record already shows at page 6 that this is a public policy and a fundamental public policy at that. And the statutory provision here is the Wagner Employment at Will Act. So the real question is whether or not the policy is publicly beneficial. A publicly beneficial policy is one that serves the interest of the public rather than the individual, and something that relates to a responsibility that one citizen owes to another. Now, courts across the country have already stated that there is no public policy more fundamental than protecting human life, and that is precisely what this public policy was intended to do. Moreover, courts have found in certain states that regulations or guidelines such as these are also enough for a basis for a finding of a public policy. However, in this case, the public policy itself that we're speaking to is that Wagner Employment at Will Act. So as I mentioned before, the key word here is reasonable. What steps did Mr. Exotic?
I'm struck by the fact that I think that Petitioner raised a very valid point that, you know, this is a situation that perhaps it's best left to the legislature to determine whether or not a cause of action actually exists. And since we don't have any authority to suggest that there are any other causes, common law causes of action based on the Wagner Employment at Will Act, why shouldn't we defer to the legislature to create that type of claim now, if it wants to?
Your Honor, the legislature has been clear. It believes that a public policy should exist under which employers must maintain safe and healthy working environments. And the only way to enforce that policy right now is to create this wrongful tort, the wrongful discharge in violation of a public policy tort, because there is no enforcement mechanism in the statute itself. So in order
shouldn't we read something into that fact? The fact that there is no cause of action that was created in the WEWA, doesn't that mean that we shouldn't interpret one to be there?
No, Your Honor, because the fact is that the legislature may not have thought that it needed to include one when such a tort was possible for there to exist by the judiciary. In fact, this is not the only state that would have this type of a tort claim available. In fact, 43 states have found public policy exceptions to the at-will doctrine. And this is precisely the type of situation where that type of tort should be found.
But the legislature has had almost 60 years to determine whether or not it wanted to create this tort, or this cause of action, rather, this common law claim. And it hasn't done anything to do that. And it's never been brought to us before. So why shouldn't we just defer to that legislature to make the decision itself?
Again, Your Honor, 2 points. Again, the legislature may not have felt that it needed to make an amendment to the statute in order to provide an enforcement mechanism when a tort like this existed in 43 other states. And to my second point, Your Honor.
Just to be clear, the tort existing in 43 other states, just the public policy exception, not a common law claim about a safe and healthy work environment, correct?
Correct. And we're not asking the court to create a common law claim for a safe and healthy working environment. We're specifically asking the court that there should be a wrongful discharge in violation of a public policy tort that is applied to this specific public policy. And in fact, That is not unusual for the state of Wagner. In fact, page 7 of the record states, and I quote, "While courts in the state of Wagner have recognized actionable claims under public policy in the past, the outbreak of COVID-19 presents a challenge that this court has not previously faced." So the question is not whether, the question really is whether Mr. Exotic violated the public policy here. And certainly Ms. Buskin has alleged sufficient facts to that, sufficient facts to pass beyond a motion to dismiss stage. Now,
Counsel, if we were to recognize such a claim, wouldn't that create a risk to employers of a flood of litigation of new claims brought to?
Your Honor, so 2 points again. First, we're not asking the court to create a claim at this moment. We're simply asking the court to allow this to proceed beyond the motion to dismiss stage. And second, the key word here is reasonable, and that is specific, meaning that depending on the situation, the question that must be asked is whether the employer behaved reasonably. So we're not asking the court to create some sort of strict liability regime where every employer who doesn't follow their state health guidelines 100% needs to be held liable. We're asking in this situation that Mr. Exotic did not behave reasonably with the information that he was provided. As Petitioner has already mentioned, he made regrettable choices. And when you look to the safety measures that he did put in place, none of them are adequate. For example, he implemented a ventilation system in the dining area, but that doesn't provide any protection to anyone in the kitchen, in the server stations, or any other part of the restaurant. The information that we don't have right now is whether Ms. Buskin spent her time in the kitchen, in the server station. We don't have information about how far those different locations are from each other, or whether the ventilation system was one that was even effective. These are all types of questions that we need to answer upon discovery.
And if we were to adopt this claim that you're suggesting that we do, you would be satisfied with a basic negligence standard?
Well, Your Honor, my co-counsel will speak directly to the gross negligence portion, but as to basic negligence, again, what we're asking is for a reasonable, for the there to be an objective standard here, whether it's reasonable for the employer to act the way that he did with the information he had. Again, we're in the middle of a novel pandemic. There are unprecedented circumstances. The Wagner Health Commission was very clear about what was necessary in this situation. It said masks are the #1 effective measure to protect yourself from a virus. That is common knowledge by June 2020. And it was unreasonable for Mr. Exotic to ignore that knowledge and prioritize the aesthetic of his restaurant over the safety of his employees.
You're not urging us to adopt a strict liability standard specifically?
Correct, Your Honor. We're not urging for that at all. This is a very fact-specific case, and it's a fact-specific inquiry. So if we're asking, of course, for this case to move beyond this stage in the proceedings, but if the court should adopt any sort of regime, it would not be a strict liability regime. Now, in this situation, Mr. Exotic risked Buskin's life for the sake of his restaurant's aesthetic, and courts have rightly found that protecting human life is the ultimate interest.
And didn't she also risk her life by her own actions prior to going back to work?
No, Your Honor. All the record states is that Ms. Buskin posed maskless for a picture. There's nothing in the record to suggest that she wasn't wearing a mask for the entire party, simply pulled it down for a picture and put it back up. We also don't know who she was at the party with. They could have been her family. Your Honor, I see my time has expired. May I answer your question and briefly conclude?
Yes.
We don't know that she was with her family, with her pod of people, or whether everyone there had just tested negative for COVID earlier that day. Moreover, she was outside for the party. And for those reasons, we ask that this court affirm the appellate court's decision and deny the defendant petitioner's motion to dismiss on the wrongful and constructive discharge claims. Thank you.
Thank you.
Thank you, counsel.
May I proceed?
Yes, you may. Mr. Rowley.
Good afternoon, Chief Justice. Good afternoon, Your Honors, and may it please the court. My name is Ben Rowley, and I represent the respondent, Carol Buskin. The court should deny Exotic's motion to dismiss because the exception to the exclusivity bar stipulated in Section 1242 of the Wagner Workers' Compensation Law applies to Ms. Buskin's claim. The exception applies to Buskin's claim of gross negligence for two reasons. The first is because workers' compensation is not an appropriate remedy When an employer knowingly increases his employees' exposure to a life-threatening, easily contractable virus, and then forbids them to take effective safety precautions. And second, because Buskin has pled sufficient facts for a finding of gross negligence under the Handley test, demonstrating Exotic's deliberate intent to harm. This is a case about the vulnerability of service industry workers during a generation-defining pandemic. These are not ordinary times, and the risks faced by service industry workers are unprecedented. Waitstaff and bartenders are not first responders. They should not be asked by their employer to put their health and safety on the line without adequate safety precautions every time they start a shift. That is exactly what Exotic required of Ms. Buskin when he told her that she had to work without a mask. Turning to my first point, Exotic's conduct falls outside of the workers' compensation bargain. It's unsurprising that
Counsel, I'm sorry. My biggest concern here is the causation piece under the Handley test. I don't see how Ms. Buskin can satisfy that either on a motion to dismiss standard or if we were to let this go to discovery, because I don't think she can prove how she got COVID-19.
Your Honor, at this point, it's important to separate the facts from speculation. At this stage, the only facts we have are the ones in the record. We know for a fact that Ms. Buskin was exposed to employees during her shift at the Tiger Lounge who had tested positive for COVID within 14 days of their shift, had not yet tested negative, were called back to work by Mr. Exotic, and were not wearing masks. We have no facts as to whether anyone at the party was COVID positive. This is an appeal for a motion to dismiss. At this stage, the record supports a finding that Buskin has pled sufficiently plausible facts to make a plausible claim, allowing this case to proceed.
But just because she was at a workplace with people who may have been positive doesn't mean that she can show that that was the proximate cause of her becoming sick. It's not like, she slipped at work and she fell and she broke her arm. We know that happened at work. She could have contracted it at the grocery store. She could have contracted it at the drugstore. She could have contracted it at the party. We have no earthly clue, and neither does she. So how could we possibly let this go to discovery to determine that?
Your Honor, this is a question of fact and is exactly what discovery is intended to unearth. In discovery, we can go through the different timelines of the COVID positive people at the Tiger Lounge. We can evaluate as to whether anyone at the party became COVID positive. But at this stage, the only facts that we have are in the record, and the record states that there's only one known instance of Ms. Buskin interacting with anyone who was possibly COVID positive within 14 days, and that interaction happened at the Tiger Lounge. Turning back to my first point, it's unsurprising that the petitioner is seeking to use the workers' compensation statute as a shield because the system is designed to protect employers from punitive damages. Petitioner speaks of balance, but fails to consider that the gross negligence exception is what makes that balance possible between employees and employers. Generally, when someone is injured at work, their exclusive remedy is workers' compensation. However, in the state of Wagner, pursuant to Section 1242 of the Wagner Workers' Compensation Law, when an employer is grossly negligent and causing an employee's injury, the exclusivity bar dissolves and the employer may be sued in tort. The workers' compensation exception exists precisely for cases such as these, where an employer's conduct, in this case refusing to allow an employee to protect herself during a deadly pandemic, especially considering that there were other employees in the restaurant that had tested positive within 14 days, is simply so egregious that it cannot adequately be addressed within workers' compensation. When we examine the facts, we find that Exotic purposefully created these unsafe conditions and knowingly put his employees in harm's way, all for the sake of aesthetics. By June 2020, COVID had killed over 100,000 people in the United States alone. One of the most dangerous aspects of COVID is that a person may be contagious without showing any symptoms. This is why most states, including the state of Wagner, implemented mask guidelines. The Wagner Health Commission guidelines, found on page 29 of the record, state that masks must be worn by restaurant staff at all times. Exotic was aware of these guidelines as he posted them at the server stations, but he chose to disregard them, sacrificing the best practices for the safety of his employees for the vibe of the restaurant. Exotic contends that these guidelines lack the necessary statutory enforcement to be held against him. However, Exotic is mistaken because the court in Handley held that the violation of safety statutes regulations, or industry norms is evidence of an unsafe working condition for the purposes of the exclusive remedy exception to workers' compensation. And these guidelines are at the very least industry customs or standards. Exotic knew that some of his employees had tested positive for COVID and were still within the 14-day isolation period, and he implemented additional safety measures that were superficial at best. They were nothing more than security theater and were designed to give the impression of safety, while functionally they were completely inadequate. These safety measures don't forgive Exotic of his conduct. All of these factors combined to create an unsafe environment. Turning now to the Handley test, the court in Handley provided a test to determine whether an employee could bring a claim outside of workers' compensation when an employer was grossly negligent. It's important to note that the Handley test acts as a means of determining deliberate intent. While petitioner raises element 3 of the Handley test, he is mistaken in his interpretation, because in order for a safety standard to be commonly accepted and well known, evidence must demonstrate not that the guidelines have the force of law, but only that an equal or similar standard was recognized by a business conducting similar activities as the employer. And in this case, restaurants across the country were implementing mask guidelines as advised by the CDC, the Wagner Health Commission, and the National Restaurant Association, which issued opening guidance in May advocating for the use of masks in the restaurant environment. In this case, elements at issue under the Handley test are elements 4 and 5. The fourth Handley element requires the employee to show that her employer knowingly disregarded the risk created by the unsafe working condition. The court in Blanco v. Capform Incorporated held that where an employer is liable for gross negligence if the employer knowingly disregards the existence of unsafe working conditions that are likely to result in injury. In cases of unsafe working conditions, courts have allowed actual knowledge to be inferred from an employer's knowledge of a continually operative dangerous condition. A continually operative dangerous condition is one that presents a very high likelihood of harm. An example of a continually operative condition that is analogous to the condition that Ms. Buskin faced can be found in the case of Golick v. Rispeski, where the plaintiff handled potentially explosive aerosol canisters without proper safety equipment. Just as every aerosol canister that the plaintiff and Golick interacted with had the potential to explode upon contact, every maskless interaction that Buskin had at the restaurant presented a threat of COVID exposure. Further, the court in Travis, yes, Your Honor.
Doesn't Exotic have to know that the staff members and or customers were in fact contagious in order to have actual knowledge?
No, Your Honor, that's exactly the purpose of the continually operative unsafe working conditions standard. An employer's actual knowledge can be inferred from their knowledge just of general unsafe conditions. And in this case, COVID is sufficient, especially considering that Ms. Buskin was not wearing a mask during her shift and interacting with other maskless patrons.
Wait a second. If it's just COVID that's sufficient, then none of his elements would make any difference.
Your Honor,
you're saying that you infer knowledge, actual knowledge, from the existence of the disease itself.
No,
that
Your Honor,
can't be the case.
Your Honor, 2 points on that. The first is that we're not inferring actual knowledge of a continually operative dangerous condition simply from the disease. It's the combination of all of these factors. It's the combination of the disease and the fact that he affirmatively told Ms. Buskin not to wear a mask while in an environment that has a heightened risk of COVID exposure. She was interacting with multiple patrons and staff members without wearing a mask, and they weren't wearing a mask as well. So that in itself is an unsafe working condition, and therefrom could be inferred that Exotic had actual knowledge. The court in Travis v. Dreiss and Crump held that when an employer disregards knowledge of a continually operative dangerous condition, the law does not permit him to claim that he had no intent to injure. Rather, the law treats the employer as though he possessed the specific intent to injure required by the workers' compensation exclusivity exception. When accepted as true, the facts demonstrate a pattern of behavior, as I was saying, Your Honor, from which a fact finder could infer Exotic's actual knowledge of the Tiger Lounge's unsafe working condition. In this case, an employee who engages with the public on a daily basis in the midst of a pandemic without the protection of a mask is risking infection each time they start a shift. For this reason, the court should consider an inadequately protected restaurant during a deadly pandemic a continually operative dangerous condition and infer therefrom that Exotic possessed actual knowledge that a high degree of risk existed and that harm was likely to occur.
But don't we have to take into account the fact that the state of Wagner and other entities allowed restaurants to reopen? And in fact, as you noted, the National Restaurant Association provided guidelines for restaurants to reopen. So couldn't Mr. Exotic have taken that to mean, okay, I'm safe to open. I'm not going to reasonably be held liable for some sort of goofy negligence claim. You know, the worst I'm going to face is workers' comp.
No, Your Honor, because the guidance that you're referring to, in all of it, it advocated for mask usage. So Mr. Exotic can't pick and choose what he wants to take from the guidance and what he doesn't want to take from the guidance and saying, I'm aware of certain aspects, saying that I can reopen, but I'm not aware that the masking is advocated for. And again, the standard is not that it has the force of law behind it, but merely that it's just kind of customary usage or industry standards at the point in time which the unsafe working condition existed.
Counsel, would you agree that the guidelines did not in fact require mask wearing?
Your Honor, that's exactly my point. They didn't necessarily require them. However, for the purposes of the Wagner workers' compensation exclusivity provision under the Handley analysis, they don't have to have the force of law behind them, nor do they even need to be a requirement. Merely saying that masks are suggested, as the CDC did, as the Wagner Health Commission guidelines did, and as the National Restaurant Association did, is evidence of an industry standard that pertains to safety measures, and that Exotic then disregarded that knowledge. That's what those elements speak to.
Do you know if Mr. Exotic's restaurant is a member of the National Restaurant Association? Would he have been aware of those guidelines?
Your Honor, there's no information in the record to suggest that he was a member of the National Restaurant Association. But again, it just speaks to common industry customs and standards at this point. And by June 2020, it was common industry custom that when you were at a restaurant, you needed to wear a mask.
Except when you're sitting at a table. You could sit at a table without a mask. So there were exceptions to this industry standard.
Your Honor, this is specifically applied to employees of the restaurant, not the patrons of the restaurant. Your Honor, the court in Millison v. DuPont held that when determining the level of risk exposure that satisfies the intentional wrong exception to the exclusive remedy provision of workers' compensation, the courts must not only examine the conduct of the employer, but also the context in which such conduct takes place. In this case, the context is a deadly and generational pandemic. Ms. Buskin is not asking the court to carve out an exception to workers' compensation for every instance of the flu or any nicks or bruises that one experiences at work. Rather, Ms. Buskin is asking this court to act in a manner consistent with the legislative intent of the Wagner workers' compensation statute. In circumstances such as these, where employees put themselves at risk of contracting a deadly virus in order to make a living, the duty of employers to maintain a safe work environment for their employees is heightened. Exotic purposefully created an unsafe environment and should not be allowed to escape consequences through workers' compensation. That's exactly why there is the statutory exception. Holding Exotic accountable for his egregious and frankly life-threatening conduct will send a message to other employers who act in a manner inconsistent not only with the health of their employees, but with public health in general. This court is interested in the principles of fairness and equity. Should an employer be forced to choose between their health and their paycheck simply due to the gross negligence of their employer? Should an employer who removes the most effective safety measures during a pandemic be allowed to continue his behavior? Ms. Buskin argues no. Jeff Exotic must be held accountable, and the court must deny his motion to dismiss and allow Ms. Buskin her day in court. Thank you, Your Honors.
Petitioners?
Thank you, Your Honor. Thank you, Your
Go
Honor.
ahead.
Just petitioner has 2 points on rebuttal. First point, following the Weitz v. England DC Circuit case from 2006, it states that aggravating factors have to make the workplace so disagreeable that prevents a reasonable employee from seeking remediation. Ms. Buskin sought no remediation at all in this case. She asked twice to wear a mask and then quit when she was told after the second time to wear a mask without seeking any remediation whatsoever.
In what way should she have sought remediation? What steps should she have taken?
She could have pursued remediation under the Wagner Employment at Will Act. She could have sought remediation under the Families First Coronavirus Relief Act. And also to the second point, seeking remediation or seeking compensation under the Wagner's Workers' Compensation Law. Which brings me to my second point on rebuttal, Your Honors. The respondent attempted at numerous times to misapply the Hanley test and raise the bar and broaden the standard by alleging that evidence of general unsafe conditions may rise to the specific intent required or to evidence specific unsafe conditions. And that has, quite simply, Your Honor, no founding in case law. Hanley requires a specific unsafe condition, specific regulations or statutes that are violated, and specific industry standards that are violated that are indicative across a whole spectrum of things. And to the respondents' attempt to
there was a well-known practice at the time in June of 2020 to wear masks. And at that point, most states were requiring the wearing of masks in restaurants by service staff. So why isn't that enough to create this standard that you're saying doesn't exist?
Well, Your Honor, it's not so much creating the standard, it's what the part that the guidelines play into that standard, that those guidelines by themselves do not have that force and effect of law, and they are not in of themselves indicative of that common industry standard that is required under the Hanley test. And for these reasons, Your Honor, we ask that this court reverse the Court of Appeals decision. Thank you.
Thank you, Mr. Veras.
Thank you, counsel.
Thank you all very much for your arguments. At this time, our final round judges will be retiring into a private room for deliberations. Of course, to our competitors, please remain in this Zoom room, at which point the judges will return after they have deliberated to announce who has won the final round, as well as announce the best final round oral advocate. And to all of our attendees who are watching on YouTube, of course, feel free to remain on that YouTube link for the final round announcement in just a few minutes.
And again, thank you so much to everyone. Incredibly, incredibly well done. And so hopefully we'll find out soon who the winner is.
Just wanted to take a minute and introduce myself to the final round competitors. Since I didn't get a chance to meet you in any of the oral arguments, my name is Heidi Moore, and I'm the chair of New York Law School's Moot Court Association. And I just wanted to congratulate you for your outstanding arguments today, and obviously in the rounds on Friday and Saturday, which led you to this point. I think you've done a fantastic job and should be super proud of yourselves. And I know we all hear this because I compete as well, that you should be proud to get to this point, but it's absolutely true, especially in this case. There were almost 40 teams that competed with us. So to get to this point is an amazing achievement, and it clearly speaks to your excellence in oral advocacy and excellence in brief writing. So congratulations, and thank you so much for competing with us.
Thank you. Thank you so much.
Thank you.
Justice McQuaid, did they provide you with the link to the deliberation room? I think you're on mute.
Now this is the good part of Zoom where we all just get to look at each other while we're all muted. So, you know, we love that part.
Of course, if this was in person, we could chat more nonchalantly.
Can I say, now that I won't look like I'm trying to curry favor, that this was just truly, I mean, I'm sort of in awe that you all were able to put this on virtually and that it went as smoothly as it did. So I hope that I speak for all the competitors in saying, like, thank you, this was great. It was very well run. I've not done another one, so I don't know if this is better, you know what I mean? But it seemed extremely great to me. So thank you guys, all of you.
Thank you. That means a lot to us. Thank you.
Yes, thank you. That means so much because, you know, we felt at moments that we had to scramble. So the fact that the competitors had a good experience, we appreciate that so much.
That's because of all the outstanding scrambling you and Carrie have been doing behind the scenes, and Susan support as well. So you know what, if it looks seamless on this end, then everything you've done is absolutely outstanding and worth it. So thank you so much. And I'm sorry we can't go out for a drink together tonight, but doesn't mean we're not going to do it at some point.
I know, I hate that. The worst part about all of this is we didn't get to have the big gala.
No Wagner
that would have been great. We could have all met each other in person, all had a good time. So
The coin toss
hopefully we get to
last
do it
night,
again.
apparently, and Wagner last year was canceled. So me and Madison and Heidi, excuse me, Heidi, you've experienced a Wagner 2 years ago?
No, because I was sick 2 years ago, so I missed it. And then last year it got canceled. And I had an absolutely gorgeous dress to wear to the Wagner ball, and it's still hanging in the closet.
That's how I felt last year. Last year before it got canceled, I had a great dress to wear, and I still am looking for something to wear it to.
Listen, hold the dresses. Hold the dresses, ladies. Hold the dresses for next year. Whether you're here or not, I'm still going to invite you guys.
Our faculty advisor, Professor Baker, told us we were doing the coin flips, obviously, for all of the advanced rounds, and that was me. For some reason, I was the designated coin flipper, but for the final round, apparently that's usually done at the Wagner Ball. So on a stage, the coin flip. So we were really happy that at least we pulled you guys in last night to be there for that. We thought it was fun, so we hope you enjoyed it.
That's excellent. Yeah, Susan, make sure that you hook us up next year for the Wagner Ball, because we're all coming back.
I'm sure all the men right now are
definitely.
thinking that they had perfect ties to wear and they never got to. So it's probably all echoed across.
Excuse me for 1 minute. I will be right back with you all.
Also, Alex, I have to ask you, I know that we're live streaming, so people may not care about this, but are you is that your library collection behind you?
No, this would be my parents.
Okay, I was gonna say, I told because obviously we're all at home. I told my roommate, I was like, this girl has an incredible library. You've got to look at this.
Well, I hope they heard that. They're listening.
I was thinking the same thing too. I was like, wow, that is beautiful. That's exactly what I want my office to look like one day, hopefully. So
we were concerned that there would be some bias against those who don't like, water for elephants or.
No, it's gorgeous. It's so nice. I love the way it looks.
Thank you.
I think they would really have to zoom in to see the titles. It's more of just a nice aesthetic background.
Okay. Are we all here? All right, all the judges are here. Panelists are here. Wait, then Stanford Johnson, Alex, okay, 1, 2, 3. Wait a second, we're missing somebody. No? Do we have everybody? Yes, we have everybody. Okay. I'm going to leave it off to my colleagues because I've been talking too much. So I'm going to let my colleagues start talking to you about individually about your performances. And when everybody's done, then I will announce the winning team and the winning oralist. Okay, so Bob, do you want to start? Robert, is it Robert or Bob? I'm not sure.
It's Scott. I'm a little screwy and I use my middle name.
Okay, be that way. See if I can. You're trying to confuse me. See?
I know, Judge. I'm sorry.
The judges confuse each other. All right,
That's
Scott,
right.
go ahead.
All right. Well, thank you. Congratulations to you all. As I was listening to all of your arguments, and it was commented on by a couple of people before we started, I was very fortunate to help offer some comments to the authors while they were preparing the fact pattern. And you brought something to life for me today, and I personally enjoyed it. And I think the way Liza's smiling, I hope she thinks so too, because it really was very, very special what you guys all did today. So on that front, thank you. Just a couple of comments. I think you all did a very strong job arguing for your clients and advocating. And that's what the whole point of moot court and this competition is about. And I think that you all did a strong job in that regard, and you all should be commended. You all had a very strong handle on the facts and the case law, and that was, exceptional. And that's the key to being a strong oralist. Mr. Stanford, I enjoyed that you brought the theme of balance out front, and then you returned to it during your argument, and you weaved it through, and then you brought us back to that at the end. And I thought that was very strong. I thought that you did a good job of answering our questions. You weren't thrown off by them. And I'm going to be reading the Palmer versus Amazon case later because I haven't read it yet. And you mentioned it enough times. I'm now intrigued, and I think I need to go take a look at this case. So well done. Mr. Veras, also well done to you. I appreciated the roadmap that you gave. Everybody gave a roadmap, which I always find helpful from a moot court's standpoint. I thought that you offered really great citations to the record and that you were very good on policy points. I felt that I would have liked to have seen you talk a little bit more about the causation problem that I think exists. And I think that the causation problem exists on anything COVID related. As I commented to my fellow judges, if you fall at work and you break your arm, you know where you did that. Nobody can really ever truly be certain where they got COVID. And I think that I would have liked to have seen that a little earlier in your argument. But I also appreciated that you came back to the balance theme at the end of your argument that your partner started. So well done on that. Ms. Rayner, also very good, strong reliance on the record. You had a good, understandable roadmap. I really enjoyed your rebuttal point right off the bat. You finished your roadmap and you rebutted the point about their mistaken reliance on the WEWA, which I still love those initials. Thanks, Liza, for that. So you really started off by doing your roadmap and doing everything and going right to a rebuttal point, and that was great. So good for you. Well done on that front. And then Mr. Rowley, I didn't put your name in my notes. I had to look at my other sheet here. You had some really great policy arguments, and you weave those throughout. And then we kind of got silent for several minutes there, and you just ran with it, and you ran with it, and you owned it, and that was strong. I did feel that you were doing a little bit of reading throughout that part of the presentation. So I think you could have done a little better job of relating to us, but you were still advocating for your clients, and that was strong. So well done to you all. Congratulations for being finalists, and best of luck to you in what will undoubtedly be strong careers for you all.
Call.
Okay. Thanks so much, Judge. So I too thought you all were spectacular. I would be so proud to see any of you on a litigation team that I was staffing. And I just think you need to be commended not only for the level of preparation, but for the skill you demonstrated in each of your presentations. You should walk away from this competition both extremely proud, but also knowing that the achievement of today is a milestone for your careers, undoubtedly, all of which will be tremendous. So congratulations on that. I will say that I thought, Mr. Stanford, you did a great job in under difficult circumstances. You did not have a sympathetic client, and the concept of balance, while you will hear a number of us didn't love it, it caught our attention, and it was absolutely a very strong device for you to bring your points forth. So it was thematically strong. You also had a wonderful command of the law and your answers, and I thought it was a rather seamless presentation and argument. Mr. Veras, you followed up nicely. You two made a terrific team. It was clear that the themes carried through both of your arguments. The road mapping on your part was excellent, as was the integration of the record into your into the points you made. I thought that it would have been compelling for you to have a discussion of causation similar to Justice DeLuca. That would have to really front load with that. It would have been very forceful and even more helpful. But you did close with balance, and again, that was a very thoughtful way to capture our attention and to understand a point. On the other side of things, Ms. Buskin's counsel had a very sympathetic. You had a sympathetic client. I would have liked to have seen more of that sympathetic client plight come out. That is not to say that you did not do your arguments, did not make your arguments well. You did. But here you had a bench living through the pandemic along with your client. We get it in a way. This was far more personal for all of us than the average case. And so that was an opportunity, potentially a missed opportunity, but it's not that you didn't present it, but it could have been done, I think, even more so. I will say that I thought the road mapping on your part, Ms. Rayner, was very strong. The integration of the record was excellent. And similarly, Mr. Rowley, you were a very forceful advocate. I thought you had great strengths. I did notice the potential for a little bit of reading. Not that reading isn't appropriate, because sometimes you need to have your arguments in front of you, but it does distract and it does take away from the ability to connect. And particularly when you have that sympathetic client, we want to feel the pain and struggle of your client through your eyes and your words. And so that was potentially limiting, but again, you did have tremendous strength. So I don't want you to think it was more negative than not. It was not. Okay, Judge Williams.
Judge McQuaid.
All right, had to take myself off mute there. So I thought you were all terrific. It was a very impressive showing. You all were very persuasive, had excellent arguments, executed them clearly, efficiently. So it was a super impressive effort by all of you. So congratulations. On an individual basis, Mr. Stanford, I thought the way you handled the court's questions was excellent. You conveyed a real eagerness to answer our questions, and I think you did a very good job in thoroughly answering each of the questions that was asked of you. So that was excellent. I thought that the clarity of your arguments and the precision in your arguments was very good too. So terrific job. Mr. Veras, one thing I really liked about your presentation is the way you integrated your presentation with Mr. Stanford's presentation. And you on a couple of occasions, you tied back to that theme of balance that had been established at the outset. And I thought that was excellent. I really appreciated that. So terrific job there. Ms. Rayner, I thought your presentation was excellent. And like Mr. DeLuca said, I really liked how you came out immediately and rebutted a principal argument from the other side. That was going to be one of my first questions, and you hit it right away. So that was terrific. Right off the bat, you connected with me as a judge and was responsive to what I was thinking. So that was excellent. Mr. Rayner, Mr. Rawley, finally. I thought, there are a few comments about, when the judges went quiet. I thought you did a really nice job of filling that time and of effectively getting in a number of very persuasive arguments. And your presentation during that quiet time from the judge, for me, you scored a lot of points, and I think it was very, very persuasive. So excellent job, all of you, really impressive job. And you would all fit in well on any litigation team for sure. So thank you.
I can't see her, but I'm told that Judge Gordon is here. So Judge, it's all in your corner.
Yeah.
There you are.
Yes. Hello. And I guess I would really just echo all the comments that you've already heard. For the petitioner, very strong arguments. Given that, honestly, just my personal opinion, a losing battle or an uphill battle, I should say. But you both gave me quite a bit to think about, and had me questioning what had been already my bias going into the arguments. Mr. Stanford, very, very impressed. I was particularly impressed. There were a number of questions right off the bat, and you took them head on. I felt answered each one thoroughly and effectively. Particularly just to start off with something as simple as masks. How hard could it be? Just wear masks. And you handled that very, very well. And so I was impressed with that. Mr. Veras also, as others have said, tying the argument between the two of you flowed very well, and you connected the theme of balance very well, handled also a number of questions very directly and persuasively. And I would agree that to me, that causation element was a difficult point for the respondent to overcome, and it would have been great to hit that a little bit harder. But again, very, very good job. For respondents, again, also very, very impressed with the handling the questions, handling them head on, and making your arguments very persuasively Ms. Rayner, and agree also with one of the earlier comments that this was, you had an easier side. Your client was, I think, just any finder of fact, any judge living through the same situation. Yes, the question of reasonableness and whether whether a petitioner's position had been reasonable, I think most people would agree that it was rather unreasonable, and that would have been great to kind of tie that unreasonableness to play that up, the harm that your client had suffered, when it could have been so easily avoided, and that it went beyond the petitioner's position went beyond what would be reasonable standards. Ms. Rayner, I thought you were, I was very impressed also with your handling of questions, that you're tuning in. I think there was a point where you were a little bit tripped up in one of the questions in terms of understanding exactly what was being asked, but once you clarified what the issue was, excellent job at addressing the question. Mr. Rowley, also great job. I know that you probably of all the contestants, you were of all the counsel that you probably had you faced the fewest questions, you were asked the fewest questions, but did very well in hitting all the points that you needed to hit. I did note that you seem to be reading, and that comes through when you're reading. And so just as a kind of a practical matter, sometimes just referring to notes and speaking and connecting with your audience would be helpful, but I thought you did an excellent job and get in the substance and in your presentation. Excellent job. And congratulations to all of you. I think all of you did amazing.
Justice Williams, before you jump back in, if I can just add one note. I received it, and it's actually not a substantive note of any kind. Professor Baker, who is the moot court advisor, had to jump off the call, as she mentioned during her opening remarks to everybody. She's teaching a class today, and her class just came back into session just after the judges finished deliberating. So she wanted me to extend her congratulations to all the competitors and the final round competitors in particular, and thank you for competing, and express her appreciation also to the other judges for the final round today. So from Professor Baker, that message. I'm sorry to interrupt, Judge.
No, it's perfectly okay. All right, I am not going to critique you in the same way that my colleagues have, because you've heard enough and you're exhausted and you're tired and enough already, all right? So what I will tell you is, after my very first criminal trial, which was the stupidest case ever, but was my first, so it was of grave significance to the world, if not to the universe. I was terrified that I was going to screw it up, and God knows crime would be rampant throughout New York City. And my best friend, a very good friend and mentor, said to me, the only thing that matters is if you're still on your feet when the verdict is announced. All right? When the verdict was announced, and I won, she was in the audience and she came up to me and she said, I see you're still standing. So I say to the four of you, even figuratively speaking, you are on your feet. You are still on your feet. You have come through a very troubling, well, not troubling, but difficult time. You have worked very, very hard, each and every one of you. That's obvious. And you've heard it from everybody. You have succeeded. You've made it. You are the finalists. And you're waiting for me to say the important thing. But before I do that, I want to talk about the one thing that nobody else talked about. And that is, perhaps because I do teach advocacy, this Zoom stuff I hate, all right? And you will hate it too. And one of the reasons that you hate it is because when you're in real time, you can actually look at people. When it's like talking to a jury, you actually look into the eyes of each juror. You can't do that effectively on Zoom, and yet you must connect. And so I would urge all of you to do your best to actually look into the camera. Some of you did it better than others because it's hard to actually try to connect with your hearers. You have to use your voice in ways that connect and give your passion despite the fact that you're Zoom rather than in real life, right? Those are things that can't really be replaced, but I suspect that this type of presentation, both for real trials and for appellate work, will continue for some time into the future because it is efficient. It may not be wildly satisfactory, but it is efficient. So you are the people who will have to learn how to master that. And I urge you to take the effort, make the effort to do that. You're already ahead of the game. The old, I should say, it's the F word that has an S at the end and 3 other letters in it. You know what I mean, right? Gaseous people. People like us who are the old gaseous people, all right? We deal with this because we must, but you will hopefully make this part of your repertoire so that you have an additional tool in your toolbox, which is the Zoom, okay? Having said all of that, congratulations to all of you. And now I'm gonna do what you've been waiting and saying, when is she gonna shut up? When is she gonna get to it? I'm there, all right? I'm told that I must give the oralist first. Mr. Stanford. Congratulations. Come on,
Thank
give
you.
him a hand, all of you. And by the way, these decisions were unanimous. Unanimous. No dissents. We didn't even have to think about it a whole heck of a lot, which doesn't mean that the other group wasn't terrific. So who was the winning team? Mr. Stanford, Mr. Veras, congratulations. You are the winning team.
Thank you so much. Thank you.
Thank you.
You're more than
Thank you.
welcome. By the way, Ms. Rayner, Mr. Rowley, you should feel terrific. You did a wonderful job. You really did. You did an incredible job. I know that doesn't mean much because I know, winning is everything. You don't really care. If you're supposed to go, oh yeah, right. Please remember that we've all said this, that you did a really terrific job. And all of us have the feeling that we could not have done at your stage of development what you have done today, this afternoon. I would have been a basket case. I wouldn't have made it to the finals. And I suspect that my fellow judges have similar feelings like, glad I don't have to deal with these people, okay? So I want you to be thankful that you had this opportunity. Thank you for giving us the opportunity. I did not do, my colleagues do a lot of this work. I never did a whole bunch of this stuff. You taught me a lot and you gave me the opportunity to, play real judge again. So thank you for that. Thank you very, very much. And thanks to my colleagues for making me feel like I was really chief judge for a minute and a half. Thank you.
Tell us which schools you're from.
Yes. Are we allowed to ask that?
Now they're allowed to disclose it. Now that it's over, they can disclose it.
Oh, okay, great.
As long as Madison and Carrie say it's okay.
It's okay.
Now it's
Carrie
okay.
and I have to admit, we had to learn how to say one of these names. Very embarrassing for us. And I think everyone will know which one it was.
Okay, so where, Mr. Stanford, Mr. Veras, what school?
We are from Duquesne University School of Law in Pittsburgh, PA.
All right. And Miss Rayner and Mr. Where is he?
Rowley.
Where is he? Where did he go? All right, well, whatever happened, where are you from?
We're from Loyola University, Chicago.
All right, excellent. Really
Outstanding.
excellent job, both of you.
Midwesterners, all of you, look at that.
Look at that, yeah, how about that? Not too shabby.
Okay, well,
Amazing job, everyone.
Madison,
to our
Karen,
computers, thank you so much.
Congratulations, everyone.
Congratulations.
Thank you. This does
Oh,
conclude the final round.
Congratulations, everyone.
Yes, absolutely. I would say,
Congratulations.
if we were in person, I'd love to buy you all drinks. I hate that we're not. Next time, call me up when you're in the city. We'll all buy drinks. And Carrie and I both echo everything the judges said. I will admit, I'm not sure there's anyone who knows the fact pattern as well as Liza, Aaron, Carrie, and I, and everyone who had a part of it. And some of those questions, I was like, oh my Lord, I don't know how I would answer that. So you guys did absolutely phenomenal. Everyone should be so proud of themselves. And we thank you all so much for being part of our competition.
Thank you all so much.
Thanks.
Thank
Have
you.
a great day, all of you. You deserve it.
You too.
Go have yourself serious drinks.
Thank you.
Congratulations to you all. Well done.
Goodbye, everyone. Thank you all
Bye.
so much.
Congratulations.